Today, we're diving into the profound intersections of law, philosophy, and pragmatism as we explore two key texts by Oliver Wendell Holmes Jr., one of the most famous and influential figures in American jurisprudence. To set the stage, I'd like to frame our discussion through the lens of two pioneering philosophers, Charles Sanders Peirce and William James, the foundational thinkers of American pragmatism. Peirce, often called the father of pragmatism, emphasized that the meaning of ideas lies in their practical effects and observable consequences rather than in abstract truths or metaphysical speculation. James, building on Peirce, popularized this approach, arguing that truth is not static but emerges from experience, experimentation, and what works in the real world. Holmes, who was contemporaries with both, sharing intellectual circles like the Metaphysical Club with Peirce and a personal friendship with James, embodied this pragmatic spirit in his legal thinking. He viewed law not as a rigid system of eternal principles, but as a living instrument shaped by social needs, empirical realities, and the consequences of human action. This pragmatic thread beautifully ties together the two texts we'll examine today. First, we'll look at Holmes's seminal discussion of trespass and negligence from his 1881 book, The Common Law. Here, Holmes shifts the focus from intentional wrongdoing or moral fault to the practical outcomes of behavior, asking not just, did you mean harm, but what foreseeable risk did your actions create, and how do they impact society? This echoes Peirce's insistence on clarity through consequences and James's experiential testing of ideas. Then we'll turn to Holmes's famous dissent in Lochner v. New York, a case decided in 1905, where he critiques the majority's invocation of liberty of contract to strike down labor regulations. Holmes argues instead for judicial restraint, allowing states to experiment with laws based on localized circumstances and exigencies. In both works, we see Holmes applying a Jamesian flexibility and a Peircean empiricism, law as a tool for adaptation, tested by its real-world effects rather than abstract absolutes. For our close readings and quotations from these passages, I'll be drawing from The Essential Holmes, selections from the letters, speeches, judicial opinions, and other writings of Oliver Wendell Holmes Jr., edited and introduced by Richard Posner. This is the text right here. Posner, himself a towering figure in legal scholarship and a former judge on the U.S. Court of Appeals for the Seventh Circuit, has long been associated with Holmes as an admirer and interpreter. His work often extends Holmes's pragmatic and economically informed approach to law, making him an ideal curator of these texts. Before we dive into the excerpt on trespass and negligence from the common law, it's worth pausing to contextualize this work historically and biographically. Holmes's The Common Law was published in 1881, emerging from a series of lectures he delivered the previous year at the Lowell Institute in Boston. At this stage in his life, Holmes was 40 years old, a battle-hardened veteran of the Civil War where he had been wounded 3 times, including at Antietam. Professionally, he was at the pinnacle of his pre-judicial career, a successful Boston lawyer in private practice, a former editor of the American Law Review, and an emerging legal scholar whose ideas were already influencing the field. This book represented a culmination of his early intellectual labors, synthesizing years of research into legal history and theory. Just a year later, in 1882, he would briefly join the faculty at Harvard Law School before being appointed to the Massachusetts Supreme Judicial Court, marking the start of his long judicial tenure that would eventually lead to the U.S. Supreme Court in 1902. To appreciate Holmes's contributions here, we must understand the state of the law of trespass and negligence in 1881. At that time, Anglo-American tort law was still evolving from its medieval roots in the rigid system of writs, formal legal actions that dictated how claims could be brought. Trespass, historically, covered direct and forcible injuries to person or property, emphasizing intentional or willful acts. Consider the underlying facts to the notorious Dred Scott case, while the action on the case handled indirect harms. Negligence, as a distinct concept, had only begun to crystallize as an independent tort in the mid-19th century, particularly through cases like Brown v. Kendall, decided in 1850 in Massachusetts, which shifted focus toward a standard of ordinary care rather than strict liability or moral fault. However, the field remains somewhat fragmented and moralistic, often tying liability to intent or ethical wrongdoing rather than objective standards. Holmes's perspective in the common law was monumental. He advocated for a more external, policy-driven approach, viewing liability through the lens of foreseeable risks and societal costs, effectively laying the groundwork for modern negligence law with its emphasis on the reasonable man standard and economic efficiency. This pragmatic reorientation of the law dovetails neatly with the state of American philosophy in 1881. Pragmatism, that distinctly homegrown school of thought emphasizing practical consequences over abstract ideals, was still in its formative years. C.S. Peirce had introduced the core pragmatic maxim in his 1878 essay, How to Make Our Ideas Clear, urging that concepts be clarified by their conceivable effects. William James, Holmes's close friend, was actively engaging with these ideas, but had not yet fully articulated his version. His seminal lectures on pragmatism wouldn't appear until 1907. The Metaphysical Club, the informal Boston gathering where Peirce, James, Holmes, and others hashed out these notions in the 1870s, had disbanded by then, but its influence lingered. In 1881, pragmatism represented an emerging intellectual current, anti-dogmatic, experiential, and attuned to Darwinian evolution, challenging European idealism and aligning neatly with Holmes's vision of law as an adaptive, empirical enterprise rather than a timeless, immutable logic. With this context in mind, let's now examine key passages from the trespass and negligence chapter in the Essential Holmes. Holmes opens this passage by stating on page 253, an act is always a voluntary muscular contraction and nothing else. The chain of physical sequences which it sets in motion or directs to the plaintiff's harm is no part of it, and very generally a long train of such consequences intervenes. To unpack what Holmes means here, especially in light of the pragmatic framework we've established, drawing from Peirce's emphasis on observable consequences and James's experiential testing, we must see this as Holmes stripping away the moralistic and internal layers that characterize legal concepts of action and liability. At its core, Holmes is redefining an act in starkly objective, almost mechanistic terms. It's merely a voluntary muscular contraction, like lifting an arm or pulling a trigger. Nothing more. This is not about the actor's intent, malice, or ethical state. Those subjective elements that dominated earlier common law writs of trespass where liability often hinged on proving willful wrongdoing. Instead, Holmes separates the act from its chain of physical sequences, the cascading effects that follow, such as a bullet flying, striking someone, and causing injury. These consequences, he insists, are no part of the act itself. They form a separate train of such consequences that may intervene gradually or unpredictably. Why this distinction? In the context of 1881's evolving tort law, Holmes is pushing for a shift from intent-based strictures to a more flexible, consequence-oriented standard. Trespass, under older views, required direct intentional force, but Holmes opens the door to negligence by focusing on foreseeability and external risks. If harm results from that muscular twitch, liability shouldn't turn on your mindset, but on whether a reasonable person could anticipate and prevent the harmful chain reaction. Such a portrayal aligns profoundly with Peirce and James's pragmatism. Peirce's pragmatic maxim demands we clarify ideas by their practical effects. Here, the meaning of an act isn't in abstract moral categories, but in its observable, real world outcomes, the harm it unleashes on society. Consider James's idea of truth as what works through experience. Holmes sounds in that idea by treating law as an experimental tool, adapting to empirical realities rather than dogmatic internals. In negligence, for instance, we don't probe the soul. We assess behaviors against societal standards of prudence, testing what practically minimizes harm in an industrializing America rife with accidents from railroads and factories. By demystifying the act this way, Holmes pragmatizes the law. It becomes less about punishing bad hearts and more about regulating conduct for public welfare, with judges and juries evaluating chains of causation through evidence and policy, not metaphysics. This sets the stage for his Lochner dissent, where similar empiricism critiques abstraction in favor of state experimentation. Consider a few more passages. These are from page 254 and 255 of the aforementioned Holmes edition. Why, Holmes says, is a man not responsible for the consequences of an act innocent in its direct and obvious effects, when those consequences would not have followed but for the intervention of a series of extraordinary, although natural, events? The reason is that, if the intervening events are of such a kind that no foresight could have been expected to look out for them, the defendant is not to blame for having failed to do so. But there is no difference in principle between the case where a natural cause or physical factor intervenes after the act in some way not to be foreseen and turns what seemed innocent to harm, and the case where such a cause or factor intervenes unknown at the time. I'm going to skip down again. The general principle of our law is that loss from accident must lie where it falls. And this principle is not affected by the fact that a human being is the instrument of misfortune. But relatively to a given human being, anything is accident which he could not fairly have been expected to contemplate as possible and therefore to avoid. The first passage I just read poses a rhetorical question about responsibility for remote consequences. Here Holmes is grappling with the boundaries of causation in tort law. He starts by acknowledging a puzzle. An act might appear harmless in its immediate scope, for example, lighting a fire on a calm day, but harm ensues only because of unusual intervening events, for example, a sudden gale carrying embers far away. His resolution hinges on the concept of foresight, not absolute prediction, but what could reasonably be expected based on ordinary human prudence. If the chain of events is so extraordinary that no one could anticipate them, liability evaporates because blame requires a failure to meet that expectation. This introduces a limiting principle. Responsibility isn't infinite, it's tethered to human limitations in perceiving risk. Implicitly, it shifts the inquiry from mere cause and effect to an evaluative standard of blameworthiness, where the defendant's accountability is measured against what was practically knowable. Building directly on this, the second passage I read extends the logic by erasing a potential temporal distinction. Holmes anticipates an objection, perhaps that unforeseen future events, post-act interventions, differ from hidden present conditions, factors existing but undetected at the moment of acting. He rejects this as illusory, arguing for symmetry. In both scenarios, the key is unforeseeability, not timing. For example, firing a gun blindly into fog, an unknown present hazard, is akin to firing on a clear day only for an expected wind to alter the bullet's path, future intervention. The principle unifying them is that innocence turns to harm due to elements beyond reasonable contemplation. This consistency reinforces the first passage's emphasis on expectation over chronology, preventing arbitrary line drawing and liability, and ensuring the law treats similar risks alike, regardless of when the surprise element manifests. The third passage I read generalizes these ideas into a broader doctrinal statement that serves as a capstone, articulating a default rule for accidents. Namely, harm stays with the victim unless shifted by some basis for fault. Human agency doesn't automatically alter this dynamic. A person causing loss isn't liable just for being involved. They're treated like any instrument. For example, a natural force. What qualifies as an accident is relativized to the actor. It's not an objective category, but defined by what they could fairly foresee and avert. The word fairly injects a normative judgment, implying a communal standard of reasonableness rather than individual subjectivity. This ties back to the prior passages by operationalizing foreseeability as the pivot for blame. If harm wasn't contemplatable and thus avoidable, it's accidental, and loss lies where it falls. Otherwise, the failure to avoid shifts responsibility. Taken together, these passages form a cohesive argument for a foresight-based model of liability, distinguishing it from stricter or more moralistic approaches. They limit causation to probable risks, promote consistency across temporal scenarios, and embed a pragmatic, in the everyday sense, default that favors non-interference unless fairness demands otherwise. This framework not only resolves the puzzles raised, but also paves the way for doctrines like proximate cause, where remote or bizarre harms are cut off. Now to the famous reasonable man or prudent man standard. Recall Holmes's demystification of acts as mere muscular contractions, his emphasis on foreseeable chains of consequences, and his relativization of accidents to what could fairly be contemplated and avoided. These elements culminate in a liability framework that's not rooted in subjective morality or absolute truth, but in practical experiential judgments about human behavior in society. At its essence, the reasonable man standard, often interchangeably called the prudent man standard in Holmes's era, serves as an objective benchmark for assessing negligence. Holmes posits that liability arises not from individual personal intent or ethical failings, but from a failure to conform to the conduct of a hypothetical, reasonable, or prudent person in similar circumstances. This isn't about what the defendant actually thought or felt. It's rather an external measure drawn from communal norms and empirical observations of how people typically act to minimize harm. For instance, where unforeseen interventions absolve blame, the standard asks, would a prudent person have anticipated and guarded against that risk? If not, no negligence. If yes, then the defendant's deviation invites liability. Holmes illustrates this vividly in the text, invoking examples like a driver navigating a crowded street or a factory owner installing safeguards, scenarios where the law evaluates actions against a generalized standard of care, not the actor's inner world. Now, the reasonable man standard emerges as a profoundly anti-dogmatic, consequence-driven tool. Peirce's pragmatic maxim, that ideas gain clarity and meaning from their conceivable practical effects, finds direct expression here. The reasonableness of conduct isn't an abstract ideal, but is tested by its observable outcomes in the real world. Does the behavior foreseeably lead to harm based on evidence from past experiences and societal patterns? If so, it's imprudent and the law intervenes to deter such risks, aligning with Peirce's call for empiricism over speculation. James, with his focus on what works through lived experience and experimentation, amplifies this notion. The standard allows for flexibility in an evolving society, adapting to new technologies and contexts, like the industrial accidents rampant in 1881, without rigid moral absolutes. It's pragmatic because it treats law as a social experiment. Juries and judges draw from collective wisdom to define prudence, refining it case by case based on what practically promotes welfare and efficiency, much like James's truth emerging from utility. The reasonable man standard limits the chain of physical sequences to those a prudent observer would predict, ensures the symmetry in handling unknown factors, whether present or future, and upholds the default that accidental losses lie where they fall, unless fairness, gauged pragmatically, shifts them. It's not individualistic. Holmes stresses that it's a community standard, reflecting aggregated experiences rather than personal quirks, which prevents eccentricity from excusing harm and echoes the pragmatic rejection of solipsism in favor of shared, testable realities. This innovation marked a departure from the intent-heavy trespass doctrines at the time, paving the way for negligence's dominance in tort law and influencing everything from modern risk assessments to policy debates. Let's turn to Lochner v. New York, a 1905 landmark Supreme Court decision from which derives the so-called Lochner era of judicial scrutiny over economic regulations. Briefly recalling the facts, the case arose from a New York statute enacted in 1895 as part of the Bake Shop Act, which capped the working hours for bakery employees at no more than 10 hours per day or 60 hours per week. This ostensibly was to protect the health of bakers, who labored in hot, flour-dusty environments prone to respiratory issues and exhaustion. Joseph Lochner, a bakery owner, was convicted and fined for permitting an employer to work more than 60 hours per week. Lochner challenged the law on constitutional grounds, arguing it infringed his rights. The Supreme Court's holding, in a 5-4 opinion written by Justice Rufus Peckham, struck down the hour limit as unconstitutional under the 14th Amendment's Due Process Clause. The majority viewed the regulation as arbitrary interference with the liberty of contract, the supposed fundamental right of employers and employees to freely negotiate the terms of employment without undue government interference. It dismissed New York's health rationale as a pretext, insisting that baking wasn't sufficiently hazardous to justify an intervention under the state's police powers, which allow regulations for public health, safety, morals, or welfare. Instead, the court saw it as paternalistic class legislation that favored labor unions over business owners, violating substantive due process by imposing unreasonable economic restrictions. This decision invalidated the law and set a precedent for heightened judicial review of progressive era reforms, often invalidating minimum wage, child labor, and other worker protections in subsequent cases. Now, why do so many libertarians admire this decision, even as it's widely criticized in modern legal circles for embodying judicial overreach? At its heart, Lochner resonates with core libertarian principles of individual liberty, limited government, and free market voluntarism. Libertarians who prioritize personal autonomy and skepticism toward state coercion see the ruling as a bulwark against nanny-state intrusions into private economic arrangements. It elevates freedom of contract to a constitutional shield, allowing consenting adults to bargain as they see fit. For instance, in an era of expanding government, much like today, Lochner symbolizes resistance to progressive regulations that libertarians view as inefficient, rent-seeking, or infringing on property rights. Libertarians often invoke it or its spirit in advocating for economic substantive due process, as seen in the challenges to occupational licensing or minimum wage laws. They appreciate how it curbs majoritarian overreach, protecting minority interests, for example, small business owners, from populist labor policies. Yet thinkers like Thomas Sowell, often characterized as a libertarian, and conservative jurists like Robert Bork praised Holmes. The latter agreed with Holmes's position in the dissent and Lochner. Why? This short dissent is a tour de force and a master class in judicial minimalism and pragmatic realism, clocking in at under 1,000 words, yet packing a punch that has reverberated through constitutional law for over a century. Holmes, writing for himself, with Justices Harlan, White, and Day joining in a separate dissent by Harlan, sharply rebukes the majority's invalidation of New York's bakery hours law. His opening salvo sets the tone. This case, he says, is decided upon an economic theory which a large part of the country does not entertain. Here, Holmes accuses the court of constitutionalizing laissez-faire economics, specifically the liberty of contract doctrine. He portrays this move as akin to enshrining Herbert Spencer's social statics, a social Darwinist tract advocating unfettered individualism, insisting that a reasonable man might think the law a proper measure of the score of health, and that the Constitution is neutral on such capitalist ideas. Delving deeper, Holmes's analysis pivots on three interlocking themes. First, judicial restraint. He argues that courts should defer to legislatures unless a law is palpably unreasonable or directly contravenes explicit constitutional text. The bakery regulation, he notes, falls within the state's police power to safeguard public health, as bakers' long hours in unventilated shops could lead to disease, a rationale supported by evidence of the era's labor conditions. Holmes dismisses the majority's skepticism of this health justification as overreach, emphasizing that the word liberty in the 14th Amendment is perverted when it is held to prevent the natural outcome of a dominant opinion, unless it infringes a fundamental principle like free speech. Second, empiricism over ideology. Echoing his common law approach, Holmes demands that legal judgments be grounded in facts and experience, not abstract theories. He lists precedents upholding similar laws, for example, Sunday closing statutes, usury caps, even prohibitions on lotteries, to show that economic regulations have long been tolerated, undermining the majority's claim of novelty or arbitrariness. Third, majoritarianism with safeguards. Holmes acknowledges that majority rule can err, but insists it's preferable to judicial fiat. The Constitution permits experiments in governance, allowing states to test policies without federal judges acting as super legislators. His famous line, "General propositions do not decide concrete cases," captures this notion. Law must adapt to specifics, not be straitjacketed by broad axioms. The dissent is, in short, a pragmatic rebuke to judicial activism, prioritizing democratic processes and observable realities over imposed economic theories. While Holmes's dissent is often hailed as a progressive or realist counter to the majority's pro-business stance, it can also be interpreted as libertarian in a Hayekian sense, drawing from Friedrich Hayek's emphasis on epistemic humility, decentralization, localism, and resistance to central planning. Hayek, the Austrian economist and Nobel laureate, argued in works like The Road to Serfdom in 1944 and The Constitution of Liberty in 1960 that human knowledge is inherently limited and dispersed. No central authority can possess the knowledge of the particular circumstances of time and place needed to direct complex societies efficiently. Instead, freedom thrives through spontaneous order, where individuals and local institutions experiment, adapt, and coordinate via markets or traditions without top-down coercion. Apply this to Holmes. His call for judicial restraint embodies epistemic humility, the recognition that federal judges and U.S. Supreme Court justices perched in the federal judiciary, lack the localized expertise to second-guess state legislatures on economic policies. In Lochner, the majority presumed superior insight into whether baking hours truly affected health or were mere union favoritism, imposing a uniform national standard rooted in their own priors. Holmes, by contrast, urges deference. Let New York experiment its law, as reasonable minds might validate it based on the ground evidence. This aligns with Hayek's knowledge problem, whereby centralized judicial overrides disrupt the decentralized discovery process. If the law fails, for example, stifles bakeries or doesn't improve health, then local voters or markets can correct it faster than a federal mandate, fostering the trial and error evolution Hayek prized over plan rigidity. On decentralization and localism, Holmes's vision treats states as laboratories, a phrase articulated by Brandeis but implicit here, allowing diverse bottom-up solutions rather than homogenizing policy through the federal judiciary. Hayek similarly advocated federalism as a check on power, enabling competition among jurisdictions. For example, people voting with their feet by moving to states with preferred regulations, which generates better outcomes through emergent order. Holmes's dissent resists the court's role as a central director, avoiding the Hayekian slippery slope whereby judicial interventions accumulate into unintended authoritarianism. Even Holmes's tolerance for majoritarian experiments can be seen as libertarian if viewed as preserving individual liberty at the state level. Citizens retain more agency in influencing nearby governments than distant ones, echoing Hayek's preference for polycentric governance over monocentric control. All right, let's tie these texts together. Both works reveal Holmes at his most characteristic, a thinker who treats law not as a fixed architecture of eternal principles, but as a dynamic, adaptive process shaped by human experience, foreseeable consequences, and societal needs. In the common law, Holmes externalizes liability, redefining acts as voluntary muscular contractions and limiting responsibility to what a prudent person could reasonably foresee and avoid. This shifts tort law from moralistic intent toward an objective, consequence-focused standard, the reasonable or prudent man, where blame attaches only when risks are practically contemplatable in the real world. The passages we analyzed underscore this. Accidents lie where they fall unless fairness, measured by empirical expectation, demands otherwise. It's a jurisprudence of restraint and realism, testing legal rules against their observable effects rather than abstract ideals. Fast forward to Lochner, and we see the same sensibility applied to constitutional adjudication. Holmes rejects the majority's elevation of liberty of contract to a near sacred dogma, insisting that courts defer to legislatures experimenting with economic policy unless a clear constitutional violation exists. He champions epistemic humility. Judges aren't omniscient planners, and decentralization, allowing states to serve as laboratories for social and economic measures grounded in local knowledge and democratic majorities. This approach mirrors the common law's emphasis on limiting judicial overreach to what experience and prudence can justify. The connecting tissue is Holmes's thoroughgoing pragmatism, law as an evolving instrument, clarified by its practical consequences, think Peirce, and validated by what works in lived experience, think James. In torts, this pragmatism manifests as an external, foresight-based standard that evolves with societal risks. In constitutional law, as deference to democratic experimentation over judicial imposition of economic theories. Both reject formalism and abstract metaphysics in favor of common sense empiricism, flexibility, and policy-driven adaptation, qualities that make Holmes's thought enduringly relevant and in an industrial, then modern America grappling with change. Ultimately, these readings show Holmes not merely as a jurist, but as a philosopher of law in the American grain, skeptical of absolutes, attuned to consequences, and committed to a common law and constitutional order that grows organically through trial, error, and collective wisdom. Whether demystifying negligence or defending legislative autonomy, Holmes invites us to view the law as a living experiment, one we refine not through dogma, but through the pragmatic test of real world effects. Thank you for listening.